afternoon, everyone. Thank you for joining us today for the webinar Law as Facilitator or Obstacle for Science-Based Marine Governance. And it is our great pleasure to have Professor David Langlet with us today to share on this topic. And let me first give some introduction about the talk today and our honorable speaker. So nowadays, the legal structure has been developed more and more complex in some sense, and it definitely influences marine science and also marine planning and business. So today, David will share with us about the role that law plays or can play in the realization of the vision of sustainable ocean use. And our speaker, David, he is the first incumbent chair in ocean governance law, established in 2015 at the School of Business, Economics and Law, University of Gothenburg. And the aim of this chair is to build the research and teaching environment that brings together disciplines such as law of the sea, environmental law, and administration law to adequately address challenges related to planning and management of the sea in an international, regional, and national context. And in his research, he has been taking an interest in the legal conditions for many marine activities, including submarine pipelines, fishing, seabed storage of CO2, and marine spatial planning and ecosystem-based management. So he's really an expert in this area. And we are very happy we could have him with us today and share on this topic. And some brief introduction to Ocean Data Factory Sweden and our webinar series, especially to those of you probably the first time here. And the mission of ODF Sweden is to enable data-driven innovation by both commercial and non-commercial actors to ensure that ocean and its resources are managed in the best possible and most sustainable way. We have several in-house innovations going on and completed, and later I can share with you web pages. You may explore more about us and our spring webinar series for the purpose of creation such knowledge sharing and kind of innovation hub in some sense. So we bring people together who are interested in this context area with different expertise and share on various topics to inspire us for further collaboration and innovation. Okay, without further delay, let's welcome David. Thank you.
Thank you very much, Yejin, for this kind introduction and for inviting me. Yes, so as you mentioned, I'm a professor of ocean governance law, so I'm a lawyer. I have a background in more general environmental and natural resources law, but for the last 5-6 years, I've been focusing mostly on marine and maritime aspects of law. I'm not sure that I have, I mean, this topic that we have, or the title is nebulous and all-encompassing in a sense. I'm not sure that I have a perfectly consistent story to tell about the role of law in relation to science-based marine governance. But what I'll try to do is to provide some examples of important areas or phenomena that brings to the fore this relationship between law and the different roles that law can play, positive or sometimes negative, in relation to marine governance, with a particular focus on data and monitoring and knowledge generation and dissemination. So that's what I hope to do for the coming approximately 30 minutes, and then we will have time for Q&As towards the end. Yes, so I know that law can oftentimes be seen as bewildering by those approaching legal issues sort of from outside the law, who are not specialized in the law as such. The law in the marine realm in particular is characterized by multi-layerness. There are many layers, there are many scales that must be considered and comprehended. There are many different forms of regulation, from the global conventions through the EU directives and regulations down into the domestic rules from national and regional lawgivers. There are many lawgivers as well in this complex. So this has been poignantly illustrated and perhaps a bit exaggerated in this much quoted article by Boylton Elliott, which is called Marine Legislation, the Ultimate Horrendogram, which was published back in 2014. I just wanted us to have a very brief look at this picture when they've tried to illustrate the bewildering multiplicity of different conventions, EU directives and regulations, and this is from a British perspective. So the green squares are legal acts in Britain, as far as I understand. And of course, this should not be construed as a precise description of the law, I think, but rather to give us a sense, a flavor of the complexity. And at the center, we have the orange squares, which then represent international agreements and conventions. So the convention, for example, UNCLOS at the very center. We have the red squares, which represents major EU legislation and EU policies with respect to the marine environment. And then further out, we have the green squares, which then are domestic legislation, in this case then in a British context. So although this is true, although this sort of depicts a reality, I would still say that yes, the law can be very bewildering, but we need to consider that these different squares and circles, they are applicable in different situations, and many of them are also not applicable to private persons. So if you're not a law scholar specializing in marine governance, or maybe a lawyer working with a governmental agency responsible for operationalizing all these different international obligations, then maybe you can be satisfied with caring primarily about the law that has or the obligations that have been somehow implemented or operationalized in the domestic law context in which you are acting. So international law obligations become relevant for private parties, individuals, companies, organizations, etc., mostly in the form of domestic law reflecting international commitments, or international law that have been reflected in EU regulations that are then directly applicable within individual countries like Sweden, or individual law that have taken the form of EU directives, which in turn need to be implemented in the form of domestic law in the individual member states. And of course, we don't always need to start with international obligations. We can have EU law in its own right. So an EU directive, for example, is mostly interesting for us as private parties when it has taken the form of domestic law. So we don't need to be as intimidated by this horrendogram as we might first think, because in most contexts we are actually only affected by a fraction of these. However, as I will get back to at the very end of today's presentation, there are many other pieces of law and policy in addition to those that we saw in this picture that can be even more important for those engaging with marine management, marine data and knowledge generation, etc. But I'll get back to that. We should also note that in the domestic context, the general obligations that are set out in laws and ordinances are oftentimes also made more specific in the form of permit conditions. So if we are engaging in activities that require a license or permit, authorities are likely then to specify what these more general obligations set out in the law actually mean with respect to our particular activity in the form of permit conditions, which then benefits sort of transparency and clarity as to what the law actually requires with respect to a particular activity. We should also note, which is important later on when we talk about, for example, the law of the sea and the right to marine scientific research that is guarded or set out in that context, that international obligations, international law and agreements between states, they generally do not generate neither obligations nor rights for private parties. So as an individual or a company or an organization, we don't generally derive rights from international agreements either. with the exception of human rights, but we're not going to talk about human rights here today. So this is not to say that there are no problems with the regulation, the legal regulation of marine activities, marine environmental management. There are many problems. There are conflicts, there are lacunas, there are what I would call bad priorities, bad from the perspective of sustainable and comprehensive management of marine resources. So just a few very brief examples would be the fact that the EU has a directive on carbon capture and storage that mandates or instructs the member states to grant, if they so choose, to grant licenses for storing captured CO2 in the seabed. And there's been a lot of amendments to EU law to enable that, to EU waste law, for example, to do away with legal obstacles for storing captured CO2 in the seabed. At the same time, however, we have this regional convention, the Helsinki Convention, concerned with the protection of the marine environment of the Baltic Sea region, which has a very clear-cut prohibition on dumping in the marine environment, which also covers injection of CO2 in the seabed. So no country, no coastal country around the Baltic Sea can actually inject CO2 in the seabed without violating its obligations according to this convention, to which the EU is also a party. So there is a clear conflict here between what the EU tries to sort of facilitate and promote, regulate through its own internal directive, and the obligations that follow from this regional international convention, to which both the EU and all the coastal states of the Baltic Sea are themselves parties. Another example of what I would call the bad priority is the EU Directive on Marine Spatial Planning, the MSP Directive. I will talk a bit about that later on. What has been done in that context is that the geographical scope of the directive has been delineated in a way that it is really inconsistent with the overarching objectives of the directive for different underlying political reasons. And we'll get back to that. So these are just very brief examples of, well, there are definitely problems, not only with sort of the complexity of the system, but also with real conflicts, real deficiencies in the law. But it's not necessarily as bewildering as it may seem in this horrendogram. Another thing that I think should be mentioned here is the reporting requirements that are oftentimes set out both in EU law and in international agreements, as well as sometimes in domestic national rules and regulations. And reporting then is being required to many different institutions in many different contexts. And this really risks adding unnecessary and sometimes unreasonable burden on many agencies. However, this, at least it doesn't directly affect private parties, individuals, companies, although it may indirectly have an effect. But it's mostly governmental agencies, etc., research institutes, etc., who may be affected by these this multiplicity of reporting requirements that are, if they're inconsistent, that it really increases the workload in a sort of unreasonable or unjustified manner. I want to talk a bit about information and data generation and the use of data against the backdrop of the ecosystem approach. The ecosystem approach, also known as the ecosystem approach to management, ecosystem-based management, etc. We may spend hours discussing about whether these concepts are really synonymous, or if there are differences, what the differences are. I'm not going to go down that road. For the purpose of this presentation, I'm going to treat them as synonymous, and we'll leave the nitty-gritty discussions to another context. So the ecosystem approach has been embraced both globally, for example, under the Convention on Biological Diversity, and the parties there have embraced the so-called Malawi principles, which tries to flesh out what the ecosystem approach implies, but also by the EU, which of course becomes more concrete and immediately pertinent from a Swedish perspective. So the ecosystem approach, or the ecosystem-based management, is the implicit basis of the EU's Water Framework Directive, which is one of the main pieces of EU law with respect to marine management. Not that the directive as such applies to the whole marine environment. It's only actually applies to coastal waters. But coastal waters are very important, of course, because that's the region or the area where we see most activities in the marine realm. It's where we have most anthropogenic impact, and it's also where water enters the ocean from freshwater, the freshwater context. And of course, a lot of the anthropogenic impact comes through freshwater inflow into the marine environment. So that makes the World Water Framework Directive highly significant also for protecting and managing marine natural resources and achieving the objectives that we have set for the marine environment. It's also explicitly, so the ecosystem approach is explicitly required both by the EU's Marine Strategy Framework Directive, the MSFD, and also it's a core component of the Common Fisheries Policy, the CFP of the EU. The CFP is mostly applied directly by the EU because this is a strongly harmonized area or policy area, whereas water management and marine environmental management are operationalized on the member state level, but within the frameworks established by these directives. So there's a difference here really on how this, or where, by whom the ecosystem approach is to be put in motion here, if it's mostly by the member states or mostly by the EU itself. It's also recently been proposed by a Swedish public inquiry called that Swedish marine governance should be governed by an ecosystem approach. And there's also been a proposed new piece of law that is to govern on a very sort of general level marine governance in Sweden, and also setting out a short, rather general definition of the ecosystem approach to be applied in that context. So what can we say about the ecosystem approach in a marine context? Well, we can say very, very much, because we have now spent, or the scientific community has spent at least 25, 30 years discussing and debating the ecosystem approach and ecosystem-based management, mostly in relation to fisheries management, but increasingly also more generally in respect to marine natural resources and marine environmental quality issues. I think it's safe to say that ecosystem approach is generally not very well defined. We do find some definitions in different pieces of EU law, but they are not completely consistent, and they are generally of a very overarching nature, so that they leave much to be fleshed out and specified when we're actually applying the approach in specific contexts. Ecosystem approach is also strongly data and monitoring dependent, so it requires a lot of monitoring, a lot of data gathering, and I'll get back to that because that's sort of at the core of my discussion today. It's scale dependent. Scale, of course, also is strongly tied to data generation and monitoring. Ecosystem approach, by necessity, treats knowledge and data as provisional. We need constantly to gather new data, and hopefully we'll have a progress in our understanding of natural processes, ecosystem processes, but also the interaction between ecosystems and the social systems with which they are interrelated, really, or interact. Many would also say that ecosystem approach implies an openness to multiple forms of data and knowledge, so not only the traditional scientifically generated data, but also more traditional or the practical knowledge held by different stakeholders and users of marine ecosystems and marine resources, etc. So although a lack of data is often not the main obstacle, at least to initiate ecosystem-based management, and although uncertainty is unavoidable in marine management, there is a big and continuous need for data generation and knowledge creation, clearly. It's been increasingly pointed out that we need both natural science and social science generated data here. Just relying on increasingly deep understanding of natural systems will not take us to sustainable use and management of coupled social and ecological marine systems. However, if we look at the pieces of law that have been developed, particularly then within the EU over the last 20 years or so, with the Water Framework Directive and the Marine Strategy Framework Directive, at the core, we can see a very strong emphasis on natural science and ecosystem data, if you like. That is particularly strong, this focus in the Water Framework Directive, which is then the older piece of law from the turn of the millennium. But it's also the main focus in the later Marine Strategy Framework Directive. So what we need here is to realize that natural science and social science, there's a strong need for mutual comprehension of the different vintage points and the different presumptions that we bring to the table, so to speak. And it's also important to recognize the specific role of law here, because law and policy influence obviously and direct to a large extent the measures that we take, both governmental agencies of various kinds, but also research is oftentimes directed by law and by priorities initiated or determined by law and publicly adopted policies. So in that sense, it also partly defines, in a way, actually, the natural phenomena that we want to understand, manage, and preserve. And this may sound radical. Some would say that marine ecosystems are a social construct. I don't think we need to be. I mean, this. It may sound very sort of postmodern. I don't think it need to be. I think we can all agree that. Although the ocean is there, irrespective of whether we look at it or not, and the waves are there, and the cod are there, and the algae are there. But as soon as we have the intention to study the cod and the algae and the currents, etc., and form some kind of knowledge about them as a system, that necessitates us making a lot of decisions about how to delineate the system, at what scale we want to study the system, the level of detail, the level of how we want to merge different sets of data, etc., etc. So inevitably, the law and the policies that direct governance and monitoring and steering of various kinds, and also research, has an impact on how we construe the natural environment, and not least, of course, the interactions between the environment and the social systems. Should also point out the fact that law is replete with concepts that are assumed to have a clear spatial nature, or otherwise have a very distinct meaning to which we can tie different kinds of legal obligations or legal implications. And these includes things like a coastline, an ecosystem, a water body, and etc. And I would think that to most natural scientists, it's completely uncontroversial to say that these are all fairly undetermined notions, that they change due to changing perceptions, changing knowledge, but also changing or as a consequence of natural processes. So, for example, if you ask anyone how long is the Swedish coastline, well, the coastline in itself, it doesn't have a particular length. It depends on the scale of measurement, obviously. And if you talk about how does this ecosystem look like, well, of course, if you're talking about a very small lake, maybe at least spatial delimitation is fairly clear. Well, of course, you may include also the interaction between the lake and the surrounding environment. But if you talk about the ocean or a part of the Baltic Sea, obviously it becomes necessary to make a lot of decisions on how to delineate the ecosystem and how to define it. And the same is the situation with the water body, which is a core fundamental concept in the Water Framework Directive, and a core sort of a point of departure for management of water resources under EU law. So it's vital that natural scientists and lawyers understand the dynamic relationship between the law and the natural environment. And once more, putting natural environment within brackets doesn't mean that I contend that there is no such thing as natural environment in its own right. But as soon as we start investigating it and sort of modeling it and managing it, of course, it requires us to impose our understanding and our definitions on what it is we are studying. So, ecosystem approach is data and monitoring intensive. That's pretty well established, I would say. If we look at the law, we can see that there are a number of pieces of not least EU law that requires us to generate data about the natural environment and the consequences of human activities on the natural environment. The oldest piece of law, it's now been updated in 2011, but originally it's from the early 1990s, is this directive on environmental impact assessment. I'm not going to go into any details, but we can see that the requirements here are pretty far-reaching with respect to major projects and activities that we want to carry out that will have or are likely to have a significant impact on the environment. Then we need in advance to assess the effects on human beings, flora and fauna, soil, water, air, climate, landscape, material assets, and also the interaction between these different points. So potentially very comprehensive gathering of data and assessment. There's also the obligation of the operators of these activities then to continuously, if they are given a license to carry out the activity, they will be required continuously to monitor, document and report on the consequences and the effects in the environment. So this can also generate a lot of data. However, this kind of data is not geographically systematic, and it's ad hoc in the sense that it is only triggered by the fact that someone wants to establish a factory or carry out some other large-scale activity at a particular place and point in time. So it doesn't generate the kind of comprehensive and systematic supervision, monitoring of the environment that we need. However, the Water Framework Directive, so the main piece of EU law in terms of managing water resources, has a strong focus on monitoring. So the surface water monitoring network shall be designed so as to provide a coherent and comprehensive overview of ecological and chemical status within each river basin, and shall permit classification of water bodies into 5 classes, etc., etc. I'm not going to go into any details. We can just note that monitoring occurs 148 times just in the text of the Water Framework Directive itself. And then there's lengthy guidance documents also on monitoring. And of course, there are a lot of people who are experts in this. We'll just note that monitoring is a strong focus of the governance model which the Water Framework Directive builds on or defines, if you like. The Marine Strategy Framework Directive, which then applies to all the marine environment, and in particular then the marine environment beyond coastal waters, where the Water Framework Directive is no longer applicable in its own right. The MSFD also has a significant focus on monitoring and assessment of the state of the environment and following up, assessing the consequences of different kinds of policy measures that have been implemented. Here, of course, we have the additional challenge that we are trying to manage resources that are shared by oftentimes many countries, like the Baltic Sea, of course, is shared by a number of coastal states. And then we need to aim for some kind of consistency or harmonization. So the member states shall here endeavor to ensure that monitoring methods are consistent across the whole marine region and to facilitate comparability of monitoring results, and also to consider transboundary impacts and features. And this adds to the challenges here. Monitoring doesn't occur quite as many times in the MSFD as in the Water Framework Directive, which I think has to do with the sort of the higher level of aggregation. The MSFD is overall less specific, less detailed, because it deals with larger processes and much larger scales as well. There's also a guidance document here. We have the newest of the main pieces of marine law in the EU, if you like, which is the Directive on Marine or Maritime Spatial Planning from 2014. So the MSPD takes a much more comprehensive or holistic approach, if you like, to marine management, not only focusing or not primarily focusing on the natural processes and natural science, but also to a large extent on social processes and demands on the natural environment from different human activities and planned or future prospective human activities. So this has the upside, of course, or the positive consequence of enabling a more comprehensive view, a more comprehensive assessment. Of course, there are also risks associated with this, that we may give a preference to usage rather than preservation, etc. There are also other problems here, among which is the fact that the MSFD leaves virtually all hard choices and trade-offs between different objectives to the individual member states. So it has very little sort of steering capacity in terms of ensuring that certain objectives are actually fulfilled or certain targets are actually met. It also, and that's what I briefly mentioned at the outset of this talk, that it excludes coastal waters falling under member states' town and country planning from its purview. So this essentially means that the marine spatial planning processes mandated by EU law are not applicable to any area of the marine realm or coastal waters, really, for which there already exists a domestically designed and implemented planning regime or planning structure. And of course, this counteracts the very idea of having a comprehensive ecosystem approach and also of considering land-sea interactions in a comprehensive way, because if you set up parallel systems of planning, you risk having a sort of a disjoint system here where the two planning processes are not fully not fully consistent and not fully communicating with each other. They may also be out of sync in terms of planning stages. So what I've argued here with my colleague and PhD student Aron Westholm is that the obligation to apply an ecosystem approach and also to consider land-sea interaction in EU law on marine spatial planning actually necessitates a very close coordination of existing planning processes and those mandated by the MSP directive, because otherwise it effectively undermines the very idea of land-sea interaction and ecosystem-based management. I won't dwell on that. If you have an interest, you can refer to this recent publication. So now I'm going to slightly change focus, and for the last few minutes I'm going to talk more specifically about marine scientific research and the legal context for marine scientific research internationally. So the main piece of international law that sort of defines many of the rights and obligations relating to the ocean and use of ocean resources, of course, is the Law of the Sea Convention from 1982, often known as UNCLOS. UNCLOS regulates marine scientific research, but it doesn't provide any clear definition of what is actually meant by marine scientific research. That is actually due to different ideas and the inability of the many negotiating parties to reach an agreement on how to define marine scientific research. So for that reason, it was left without a clear definition. It is clear, however, that it does not cover exploration and exploitation with that, because those kinds of activities are regulated in a different way in their own right. We know that knowledge resulting from marine scientific research shall be made available by publication and dissemination to the extent that you're not willing to make the results, the data that you gather, or the knowledge that you generate publicly available, then you can't claim to be conducting marine scientific research as understood by UNCLOS. There is a right to conduct marine scientific research on the high seas, so beyond the areas that are subject to coastal state jurisdiction. We should note once more what I said initially, that rights that are set out in international agreements do not accrue to individuals, not to physical persons, not to companies and organizations, but to states. So if these rights are violated, it's not an individual who can complain. It's the state, the home state, that can bring this and make this a matter of an international violation of international law. Of course, there may be a possibility for you as a scientist or organization to avail yourself of the court system of the country that you think has violated UNCLOS, but they may not apply UNCLOS. They will apply the domestic laws of that country, and those may not be consistent with UNCLOS and the rights to carry out marine scientific research set out in international law. In the territorial sea and on the continental shelf, in all marine areas that are subject to coastal state jurisdiction, so the territorial sea, the continental shelf, and the so-called exclusive economic zone, marine scientific research always requires consent by the coastal state in any of these areas. However, with respect to the continental shelf and the exclusive economic zone, which means beyond 12 nautical miles from the baseline, and the baseline is oftentimes the same as the coast. So typically beyond 12 nautical miles seawards of the coast, there will be a presumption for consent. So in normal circumstances, the coastal state should grant a license for marine scientific research in the EEZ or on the continental shelf, provided that the research is for peaceful purposes and aims to increase scientific knowledge of the marine environment for the benefit of all mankind. Of course, that also links what I said before of this expectation that the results should be made publicly available. There is no presumption that a license or a consent should be given if the research is of direct significance for the exploration and exploitation of natural resources. So in such cases, the coastal state remains free to say no to any request for such research. The same applies if the research involves drilling on the continental shelf or the introduction of any harmful substances in the environment, or if it involves construction, operation, or use of artificial islands, installations, or structures. So in those cases, there is no presumption that you will be allowed to engage in marine scientific research in the EEZ or on the continental shelf. Then also, of course, these international obligations, the rights laid down in UNCLOS, they are commitments made by countries vis-à-vis each other. So, for example, Sweden is a party to UNCLOS, so by signing the convention, or ratifying the convention, we commit to opening up our marine areas according to UNCLOS to the citizens of other countries who are also parties to this convention, and to the ships flying the flag of these other parties. But it doesn't affect the legal status of Swedish citizens or ships flying Swedish flag in Swedish marine waters, because it doesn't affect the relationship between me as a Swedish citizen and the Swedish government. So states internally may have different kinds of requirements in relation to its own citizens and ships. So, for example, in the Swedish context, we know that there are requirements of consent by the armed forces for any hydrographic surveys, and that's been much discussed because it oftentimes imposes significant restrictions or challenges for anyone wanting to carry out many kinds of surveys in Swedish territorial waters in particular. And there are also practical challenges for private persons relating to many other pieces of law. And that's what I said initially also when you looked at this horrendogram, that it was very much focused on laws and regulations that focus specifically on marine issues, marine matters, and marine environment, marine resources, etc. But practically speaking, when we want to engage in marine management, marine monitoring, etc., we oftentimes run into legal obstacles or legal challenges that are not at all related to marine-specific law or policy, but to general provisions of law dealing, for example, with privacy, so the GDPR, intellectual property rights, rules on secrecy and access to information, etc. And that's not what I've covered this far, but I will be happy to explore these perspectives with those of you who have encountered such challenges in your practical work. And that brings me to the end of my presentation. I don't think I've overrun the time that much, at least. So now I'll be happy to try to answer any questions as best as I can.
Thank you very much, David. Yeah, thank you for explaining the complicated legal requirements in this context. And we welcome questions from our audience.